Hi, this is the business guy. So what is a trust? What's a trustee, a settlor, a beneficiary, and why do lawyers love throwing around terms like common law and civil law? Well, sit back, grab a snack, and get comfortable because we're going to unpack all of it in a way that's both fun and easy to understand. I'm the CEO of Asset Protection Planners. We have attorneys on staff and are the nation's largest asset protection firm. And if you appreciate this information, click subscribe so we can see each other again. All right, let's start with the basics. A trust is like a legal bucket. You put things into the bucket like your money, your home, your prized collection of antique spoons, and the bucket is managed by somebody else for the benefit of somebody else. Now, it depends on the type of trust that you have. With a living trust, for example, those can all be you. But wait, let's break it down a little further with a little pizzazz. Imagine a trust as a container. You as the settlor are the one who puts the assets into the container. The trustee is the one holding the container, making sure it doesn't spill. And the beneficiary is the person or people who eventually get to take things out of that container. Now, a trust can hold about anything: money, property, stocks, and even that giant inflatable swan in your pool. But why would you use a trust instead of just handing over your assets? The answer: control, protection, and privacy. A trust can make sure your assets are handled according to your wishes, even after you're not around to give directions. Okay, now let's get to know the stars of our show: the settlor, the trustee, and the beneficiaries. Now, the settlor, also known as the grantor or trustor, is the person who creates the trust. They're the one with the vision saying, I want my assets managed this way. Think of the settlor as the director of a movie. They set the rules, they pick the actors, and write the script. Now, if you call us and have us set up a trust, that would usually be you. Next, we have the trustee. This is the person, or sometimes a company, and it's like a movie producer. They make sure everything goes according to the script. Trustees manage the assets in the trust, making decisions based on what's in the trust document. But unlike a movie producer, they're legally obligated to put the beneficiary's interest first. No skimming off the top for a luxury yacht here. And finally, the beneficiary. And they're the star of the show, the ones who benefit from the trust. The trustee might manage the assets, but ultimately it's the beneficiary who gets to enjoy those assets. Whether that's income, property, or a nice annual payout, the beneficiary reaps the rewards. Okay, now you may have heard terms like common law and civil law thrown around, but what does that have to do with the trusts? Well, let's talk about how these two legal systems view trust, because it makes a big difference. In common law countries like the United States, the UK, Canada, and Australia, trusts are a big deal. Common law is all about precedent, meaning decisions from previous court cases guide future ones. It's like that friend who always says, well, last time we did it this way. I mean, we all have that friend, right? Now, civil law countries like most of Europe and parts of Latin America focus more on written statutes than on judicial decisions. Trusts aren't ingrained into the civil law world, so they can be a bit more challenging to navigate. But don't worry, if you have assets in a civil law country, there are still ways to set up trusts or similar structures with the help of a good attorney. Okay, now that we know the key players, let's talk about the types of trusts. Oh yes, there's a trust for every occasion, like a Swiss Army knife, but for your assets. First up, we have the revocable trust. It's like having a car with a reverse gear. You can change your mind after the trust is set up, or even dissolve it altogether. Revocable trusts are great for managing assets during your lifetime and avoiding probate when you pass away. Okay, next there's the irrevocable trust. This one's like a one-way ticket. Once you set it up, you can't readily undo it, but here's the catch: it's much better for protecting your assets from creditors, lawsuits, and taxes. And the nice thing is, if the trust is drafted properly, you can have the trustee make certain changes according to your wishes. Once assets go in, they're no longer considered yours, which can be a huge benefit in the right situation. Okay, let's talk about a living trust. A living trust is created while you're alive, and a testamentary trust is created through your will after you pass away. Think of the living trust as a pre-planned vacation, and a testamentary trust as one that starts the moment you're off the plane. Now, why should you even bother with a trust? Well, here are the top reasons. Avoiding probate. With a living trust, your assets don't have to go through the public, expensive, and time-consuming probate process. It's like taking the express lane instead of being stuck in traffic. Second, asset protection. An irrevocable trust can shield your assets from creditors, lawsuits, or even long-term care costs. Now, an irrevocable trust does not automatically make it an asset protection trust. In order for it to provide asset protection, it must be drafted properly in the proper jurisdiction and have an independent third-party trustee. So it's like putting your valuables into a vault with a big do not touch sign. Tax planning. Trusts can help reduce estate taxes. Now, sure, Uncle Sam can always get a slice, but with a trust, you can help make sure he doesn't get the whole pie. Control beyond the grave. Want to make sure that your 18-year-old doesn't blow their inheritance on a sports car? A trust lets you dole out money over time, ensuring that your wishes are respected even after you're gone. After all, you don't want your children buying Lamborghinis in every color. Okay, let's talk about a few real-life examples that show just how powerful a trust can be. Example number one, the billionaire's secret. Jeff Bezos, the founder of Amazon, uses trusts to help manage his wealth. By placing his assets into a trust, he can control how they are distributed, avoid public scrutiny, and ensure his family's financial security. Example number two, protecting the family home. Let's say Sarah, a business owner, sets up an irrevocable trust. When a lawsuit threatens her company, her home, which is in the trust, it's untouchable. The creditors come knocking, but the trust is like a no trespassing sign. Now, if real estate is a little bit different, we need to add equity stripping strategies in many cases. See my video on real estate asset protection. Example three, leaving a legacy. Bill and Melinda Gates use a charitable trust and foundation to direct their wealth into causes they care about. Not only does this provide them with tremendous tax benefits, it also allows them to make lasting impacts on the world. Now, did you know that over 60% of high net worth individuals use trusts as part of their estate planning? And according to the IRS, trusts hold over $5 trillion of assets in the United States alone. Trusts aren't just for the ultra wealthy, they're for anyone who wants to plan wisely for the future. And here's a fun fact. The concept of trusts dates back to the Crusades. Knights would transfer their land to trusted friends before heading off to war, so the property would be managed in their absence. And you thought estate planning was boring, right? Okay, let's tackle a few misconceptions, shall we? Because there are a lot of confusion out there about how trusts really work. Misconception number one, trusts are only for the ultra rich. Nope, trusts are useful for anyone who wants to protect their assets, avoid probate, or control how their wealth is distributed. Even if you don't have a yacht, a private jet, or a couple of $1 million in the bank, a trust can be a great tool for keeping what you've worked so hard for safe. Misconception number two, trusts are only for old people. Not true. Trusts are actually most effective when you set them up early. Think of it like planting a tree. The sooner you plant it, the bigger and stronger that it grows. Plus, setting up a trust before you face legal trouble can mean the difference between keeping and losing your assets. Misconception number three, trusts are complicated and expensive. Sure, trusts can be complex, but they don't have to be. A good attorney or trust specialist can walk you through the process, and the peace of mind you get is priceless. Yes, setting up a basic irrevocable trust might set you back several $1,000s, but avoiding probate or shielding assets from lawsuits can save you tons, maybe even millions of dollars later on. Okay, let's take a quick tour around the world, shall we? Because not all countries see trusts the same way. In the US and the UK, trusts are a big deal thanks to the common law system. But head over to France or Germany and you find that civil law countries don't have the same legal framework for trusts. Instead, they use things like foundations or fiduciary structures. And then there's Switzerland that blends civil law with some unique trust structures. In some places, trusts aren't even legally recognized, but that hasn't stopped creative attorneys from adopting similar structures to provide many of the same benefits. And if you really want to supercharge your asset protection, offshore trusts like those in the Cook Islands, Belize, or Nevis can be your best friend. In fact, I've set up more Cook Islands trusts than anybody in the world. And as we've covered before, these are places where your assets can enjoy tropical vacations far away from the reach of the U.S. courts. Okay, so when's the right time to set up a trust? Well, if you got assets to protect, a family to look after, or other concerns such as taxes and probate, the time might just be now. Setting up a trust before any legal issues arise is crucial because if you wait until a lawsuit or other issues in the works, you may not be able to move your assets without getting into legal trouble. For example, with divorce, there is the financial restraining order tying your hands from moving any money. So you need to act early if your assets are threatened. I mean, think of it like insurance. You wouldn't wait until after a car crash to buy insurance, right? Same goes for trusts. They're typically a forward-thinking move, not a reaction to trouble. However, offshore trusts may work if you're already in hot water in certain circumstances. Tailor-made trusts. Trusts aren't just a one-size-fits-all solution. There are many specialized types of trusts that cater to specific needs. That's why we have an asset protection trust drafting attorney on staff who drafts the trust for our clients. Special needs trusts. For people with disabilities, these trusts ensure that they receive the financial support they need without losing the eligibility for government benefits. Spendthrift trusts. Got a beneficiary who isn't the best with their money? This type of trust can control how and when distributions are made to prevent them from blowing right through their inheritance too quickly. Want to leave a legacy for your favorite cause? Charitable trusts let you support a non-profit organization while enjoying some tax benefits along the way. It's a win-win. And yes, charitable trusts are the secret weapon of many wealthy families who want to make a difference and save on taxes. It's like giving a gift that gives back. Okay, so let's say you're convinced you want a trust. What now? Well, setting up a trust is a lot like buying a home. You need the right paperwork, a good advisor, and a clear idea of what you want. Do you want control or do you want maximum protection? This will help you to decide between a revocable or irrevocable trust. Have a professional draft a trust document. This is your rule book detailing how the trust will work, what assets are included, and how they'll be managed. Step 3 is transfer assets. You have to formally transfer ownership of the assets into the trust. Setting up a trust without putting assets into it is like having a worthless stack of paper. So this is like moving your valuables into a new safe. Step 4, choose a trustee. Now, when we set up an asset protection trust, we do that for you. Make sure it's somebody who you trust, pun intended, because they'll be the ones helping you manage everything, so you want somebody who knows what they're doing and has your best interest in mind. Now, here's a little secret for you. When we set up an asset protection trust, we typically stick an LLC inside the trust, make you the manager and the signatory in the bank accounts. When the bad thing happens, you can have our trustee law firm step in as manager and stand in the way of legal trouble to protect you. Now, if everything we talked about sounds like a lot, don't worry. That's why professionals like me and my team exist. We've set up thousands of these trusts, and with the right guidance, it's not as intimidating as it sounds. So there you have it, a deep dive into the world of trusts, from the basics to the technical details with a dash of humor along the way. If you learned something new today, please smash the like button, subscribe for more videos like this, and drop your comments below if you have any questions. And if you're thinking about setting up a trust yourself, head over to our website at assetprotectionplanners.com, fill out a form for a free consultation. And remember, it's not about being paranoid, it's about being prepared. So until next time, stay safe, stay protected, and keep building your future. I'm the business guy, and we'll see you in the next video.